Good morning, everybody, and thank you for joining me this morning on this seminar. We're going to be looking at three important cases with relevance to highways and housing law. We're going to be looking at McGeown, Gulliksen and Barlow, bit of a refresher. My name is Elizabeth Bauer. I'm a partner in the insurance department at Forbes. So I'm just going to share my screen with you and the PowerPoint from the beginning. I'm going to turn my camera off, I think, so that you can concentrate on the slides a little bit better. And then you're not seeing me waving my hands about as I'm talking. So if we just share this from the beginning. And then I think that you should be able to see my slides, I think, now. So yeah, there we go. So we're going to look at these three cases, I think, in detail. McGeown, Northern Ireland Housing Executive, Gulliksen, Pembrokeshire County Council, and Barlow and Wigan Council, the most recent case, although that is now 4 years ago. Perhaps it's useful, I think, at this juncture, really to just have a recap on the history of highways, as I think that can really assist in understanding the status of highways, the cases that we're going to look at in this seminar. I'm going to apologise at the outset. This is not the most sexy topic. The cases aren't particularly exciting in terms of facts, because they're all just involve people tripping in fairly basic circumstances over tree roots or paving slabs. So they're fairly run-of-the-mill accident claims. So it isn't the most exciting subject, but for anybody dealing with highway claims, it's something that you do need to think about, and housing claims as well. So we need to go back really into the mists of time, back to the Highways Act in 1835. And prior to that enactment, all highways were subject to certain exceptions, maintainable by the inhabitants at large. So a responsibility that then fell onto the local parish. And when the Highways Act in 1835 came in, it relieved the parish of its responsibilities in respect of highways constructed or dedicated after the enactment of 1835, except if they were constructed or dedicated and certain conditions were met, allowing to the highway to be effectively adopted. The Act, however, didn't apply to footpaths, probably just in a bit of an error of drafting. And obviously, when you had roads with paths running along the sides of them, then they would be included. But pure footpaths weren't included under the enactment of the Housing Act 1835, and the parish continued to remain responsible for their repair and maintenance. So to correct that, it took until 1949, and we had the catchily titled National Parks and Access to Countrysides Act 1949, which extended the Highways Act 1835 obligations to footpaths dedicated as highways after the commencement of that act. So after the 16th of December 1949. And the effect of that act was to make any public paths that were in existence to be repairable by inhabitants at large, whether they were constructed before or after the commencement of that act. But liability for the path only fell on the inhabitants if they were dedicated after 1949, if they were dedicated or adopted subject to the conditions provided for in the original Highways Act in 1835. So from 1949, local authorities produced a definitive map, as I'm sure most of you are aware, which showed all the public rights of way that were in existence at the time of the Act came into force and were classed as repairable by the inhabitants at large. And although definitive maps are very useful, they're not absolutely conclusive to prove that a particular footpath is maintained or not. And sometimes you do need to make further inquiries, but they are a very good starting point. Section 38 of the Highways Act 1959, so we're moving on 10 years, then provided that after the commencement of that Act, no duty in respect of maintenance of highway should lie on the inhabitants at large of any area, but the highway might become highway maintainable at public expense, the phrase that we now understand, in accordance with the provisions of Section 38, which set out which highways would be so maintainable, so effectively by the local authority. These included highways, which the ones we're going to look at for the relevance of this seminar, with those which immediately before the commencement of the 1959 Act were maintainable by the inhabitants at large or maintainable by a highway authority, and also highways constructed by a local authority under Part 5 of the Housing Act 1957. We then move on again to the Highways Act 1980, which in effect was a consolidating act. In Section 36(1) provides that all highways that were maintainable at public expense immediately before the commencement of the 1980 Act, for the purposes of the previous Highways Act, continued to be maintainable. So the other questions that you need to consider are, who owns the land? Is it a highway? When was it constructed and by whom? Is it a highway maintainable at public expense? Is it a public right of way? And are there any restrictions over its use? So those are all questions that you need to be thinking about when we consider highways. But the first and I think the main fundamental question that we need to be asking is, what's a public right of way? You need to understand what that is before you can move on to thinking about liability. So a highway, public right of way, is a way over which there exists a public right of passage, a right for all Her Majesty's subjects at all seasons of the year freely and at their wills to pass and repass without let or hindrance. Can you infer an objective intention by the landowner to dedicate the right to the public to pass and repass at all times? Or is it a highway under Section 31 of the Highways Act 1980, following 20 years use of right by members of the public? That's calculated retrospectively from the date that the right of way came into question. So you go back 20 years from when you first considered whether there was an issue with its status. That should not be confused with highways maintainable at public expense within the meaning of Section 36 of the Highways Act 1980, for which the highway authority is responsible. They're two quite different things. And a lot of claimant solicitors assume that if it's a highway classed under Section 31 with 20 years user, that it then automatically becomes highway maintainable at public expense. And that is just not the case. They have two different meanings completely. So in the majority of cases, when you're dealing with a housing claim or a highways claim, the status of a particular right of way isn't going to be an issue. And it's either going to be a highway maintainable at public expense within the meaning of Section 36, or it's going to be a right of way over land that the defendant may occupy, and that's going to be covered by Occupiers Liability Act 1957 or 1984. So the first case that we're going to just recap on is the case of McGeown. Again, I'm afraid not terribly sexy, exciting accident, fairly standard. Claimant was tripped over a hole in a footpath passing through a housing estate. The defendant was a housing authority and owned the land, but the public had acquired a right of way over a number of footpaths which crossed the land. In this case, went all the way to the House of Lords. And the House of Lords first confirmed that the owner of land over which a public right of way passes is under no liability for what we call negligent non-feasance. So that's liability for effectively not doing anything towards members of the public using it. So the liability of a landowner is limited to acts of positive misfeasance, so liability for positive wrongdoing and nothing else. So if on a path you create a hole or you saw off a signpost and leave a big piece sticking out and somebody trips over it, that's a positive wrongdoing, and then you're going to be liable for that. But if there's going to be just a hole in the path that you've not repaired, then that's not taking any action, negligence, non-feasance, and under McGeown, then the landowner is not liable for that. Secondly, in this case, and in most cases concerning a public right-of-way, the person using the public right-of-way will not in fact be a visitor for the purposes of the Occupiers Liability Act 1957. But for a person to be a visitor, he will be regarded as an invitee or a licensee and be treated as such. So that's going to include people lawfully using premises such as, say, a public park or a shopping centre, or somebody entering with lawful authority, for example, a policeman perhaps with a search warrant. Merely crossing land in pursuance of a public or private right of way will not deem a person to be a visitor, as there's no permission required by the occupier if you're using the path as a right of way. And that would seem sensible, really, because, for example, you may have a desire path across a field or grassed area that's been in use for over 20 years. It would seem unreasonable for a landlord then to become liable for the maintenance of that path when he's not created it in the first place, and it's just become something that people have used over time. What you do need to be aware is that the courts don't particularly like the McGeown defence. It's an all or nothing defence, and it is a tricky one to run. You do need to be very sure of your facts and your evidence if you are intending to run it. So, how do you run a McGeown defence, and what should you consider? Well, as a starting point, the first thing to look at is it a highway? If it is, the second question is it maintainable at public expense? If it's not a highway, then you just carry on as normal. Normal principles of the Occupiers Liability Act 1957 would apply. If it is maintainable at public expense, then the responsibility would pass to the Highway Authority, who would maintain it under Section 41 of the Highways Act 1980. If it isn't, then you'd carry on to consider whether or not it's a common law highway or a dedicated highway under Section 31 of the Highway Act under the 20-year user rule. If it isn't, then again, occupiers liability would apply. And if it is, then happy days, let's give McGeown a go. And just remembering that there's no liability for non-feasance. So practically, how do you defend under McGeown? Well, I would certainly consider carefully about the evidence that you can obtain in order to defend these cases. And sometimes that you need to sort of cast your net a little bit wider. It needs to be somebody with personal evidence of the use of this path. And it needs to be evidence that you can pinpoint when the path came into existence. I've run cases before where I've had to do a lot of digging to find evidence that would support a defence of this nature, and it can be quite tricky. You also need to consider as well the claimant's use of that right of way. You're on much stronger ground with a McGeown defence if you can show that they were using this path as a right of way rather than they were using the amenities in, say, a park or a shopping centre. It's not impossible. If you have a claimant who says, well, I was walking through the park because I was using it as a shortcut to get from A to B, they are using that as a public right of way, and you've got a much stronger argument that they're not there as a visitor to use the facilities within the park. Carrying out repairs doesn't amount to admission of liability or responsibility, as long as I've said before that it's not that the repair which created the defect in the first place, because that would be misfeasance. So moving on, we're going to look at Gulliksen and Pembrokeshire County Council. This case, I think, caused a lot of difficulties and controversy when it first came out. It didn't change the law in any way at all, but it just highlighted the law as it had always been. So in this case, claimant was involved in a trip on a housing estate footpath in 1999. path had been constructed in the 1970s as part of a housing estate constructed by the local authority. It was accepted that the path was a public right-of-way. There was no dispute about that. At first instance, the court held that the council was the highway authority and was in breach of the Highways Act 1980. There was an appeal to the High Court, and in the High Court, it was held that the path was not highways maintainable at public expense, and the court made the distinction between the local authority with its hat as a highway authority exercising their duties under the Highways Act, and also as a housing authority. I like to call it like the two-hat approach. The High Court held that Section 41 therefore wasn't applicable, and that issue continues to exercise the court's mind. And when we look at Barlow, that was one of the issues that came before the court in that case as well. The Court of Appeal overturned the High Court decision and held that the path was highway maintainable at public expense, but not because that the two-hat approach was wrong. So if we just look at the logic behind that, the key issue was whether the council owed a duty to maintain the footpath. As no local authority can provide housing except under statutory authority, the court accepted that it was an exercise of its powers contained in Part 5 of the Housing Act 1957, and that the path had been created. Once a highway maintainable at public expense, it's always a highway maintainable at public expense, and therefore the court held that it continued to be so. The highway had been constructed pursuant to Part 5 of the Housing Act, and therefore it was deemed highway maintainable at the public expense. What are the implications of that? Well, if the path in question, which was accepted, was one to which the public had a right of way, was not highway maintainable at the public expense, then there'd be no liability to maintain it at common law. So you'd be looking to fall back on the McGeown defence, and that would be the housing or the occupiers of the land's responsibility to look at that, because the local authority would not be looked to as a potential defendant for that case. As the path was found to be maintainable at public expense, there was a liability in the local authorities. They'd failed to maintain it because they didn't know they were supposed to in the first place. And this applied to any highway authority, even if they'd also always considered the land to be the responsibility of the housing department, or if it had been subject to, of a stock transfer to a housing provider. Some stock transfers can have indemnity clauses built in, and it's always worth having a look at those, but some don't. So in that case, then the responsibility would continue to fall on the highway authority. It did place significant burden on highway authorities who didn't realise that these roads and paths were their responsibility. And 20 years on, I think the majority of highway authorities are now alive to Gulliksen issues, but we still do see some issues going forward with housing providers arguing that paths should be the local authority's responsibility. Tends to be a lot of those cases built in the sort of 1970s where there's a lot of little paths going around housing estates which don't seem to sort of lead anywhere, and so there can be some dispute with the local authority as to whose responsibility those are. I mean, there are some exceptions. I would say that paths leading directly to the doors of houses or flats won't fall within the definition. They're going to remain the responsibility of the housing provider. Paths across common areas, such as grassy areas within estates, may not be highway. They may not have been in existence for more than 20 years, and so fall outside the definition. And on the face of it, they're going to be the responsibility of the housing provider, but you may be able to argue a McGowan defence in those circumstances. Sometimes it's useful to double check as well to make sure that the paths were constructed at the time the housing estate was constructed, because if they've been put in afterwards, then it may well be that you could argue that they weren't constructed as part of the housing estate in the first place, and therefore not constructed under Part 5 of the Housing Act 1957. Stock transfer agreements, as I said, can provide responsibility and indemnity clauses in relation to the responsibility of maintenance and repair. So it's a really good idea to just check those and see where you are with those. So, key questions to consider. First of all, is it a footpath or a road or a highway? And is it shown on the definitive map? Although, as I said, that doesn't necessarily mean that it's definitely going to be not a public right-of-way maintainable at public expense. Has the footpath road been in use by members of the public generally without interruption and challenge? And in 1949, so we're going back to a bit of history again, was the footpath in use generally by members of the public without interruption or challenge? Or more unlikely, although I have had a case in the last few years where there was an argument that the road had been constructed before 1835. So again, we need to consider whether the road had been constructed as an ancient highway prior to 1835. If the answer to these questions is yes, then almost certainly it's going to be a highway maintainable at public expense. If not, then potentially the liability is going to be under the Occupiers Liability Act. Further questions that you need to think about. And if the answer to any of these questions is yes, then it's likely to be highway maintainable at public expense. So if the road's been subject to adoption, public path creation or diversion order, if it was constructed by the Highway Authority acting on its own behalf, or, as we've said, during the course of constructing housing since 1957, or as part of a trunk road or a special road, then it's going to be highway maintainable at public expense. If it's not going to be a yes answer to any of these questions, then again, you go back to whether it's going to be a case that you can run McGeown as a housing provider or a land or an occupier. But one thing I would mention, which is an interesting anomaly, is that there's a potential black hole on housing estate paths built post 1949 and pre 1957, when potentially no one will be responsible for the maintenance of footpaths if they've not been formally adopted. So they've not been constructed under Part 5 of the Housing Act, and they've come into existence post the 1949 National Parks and Access to Countryside Act. So practical issues, as I said, have a look about when the estate was constructed. Was it pre or post 1957, and who constructed it? It's not always obvious, and so you do need to get some evidence, which again can be tricky. Land registry documents can help, so you can do searches through the land registry to see when some of the properties on that estate were constructed. Old house files can pinpoint construction if you still have them, but often those have now disappeared. So it can take quite a bit of digging to find out the information that you need. So finally, we're going to have a look at Barlow and Wigan Council. This isn't Deirdre, which might have made the claim slightly more exciting, but Mrs. Barlow was walking along a footpath in Abram Park in Wigan in September 2014. She tripped over an exposed tree root, and there was no dispute that the tree root was dangerous, but there was a dispute as to whether the defendant owed the claimant any duty of care under Section 41 of the Highways Act 1980, or indeed under Section 2 of the Occupiers Liability Act 1957. The case, although the circumstances of the case were very straightforward, the actual case itself was quite complicated, mainly because of a lack of pleading against the local authority initially as an occupier, and the case proceeded on the basis that the claimant alleged that the highway that the claimant was walking on was maintainable at public expense. There was no system or no real system of inspection and maintenance in the park at the time that the local authority could rely on. And the claimant was walking through the park to get from one side to the other. There was a lot of housing that had been constructed around the estate from when the park originally had been put in. It was an old park constructed sometime in the 1930s. Nobody knew exactly when. And the paths were constructed sometime before 1959 by the council or their predecessor. But again, nobody knew exactly when. And the paths in the park weren't listed on the definitive map as public rights of way. Pre-issue, the defendant had argued that McGeown applied and had admitted that the path was a public right of way. There were no gates on the park, no local bylaws closing the park at night. The claimant didn't then plead the case under occupier's liability. So the only claim against the council that proceeded was on the basis that they were highway authority. And unfortunately, as I said, that did make the matter very much more complicated. The Court of Appeal, I think it's just worth just saying this to you. The Court of Appeal noted at the start of the judgment, it might be thought that the question of whether she had a valid legal claim against the present owners and occupiers of the park would be a straightforward one. Far from it. Although the material facts are scarcely in dispute, the case has already resulted in 2 different decisions by judges in the County Court and High Court, and the authorities cited by counsel include 5 cases from the 19th century, and some of the issues raised have not been authoritatively decided upon at appellate level. So not straightforward at all. It does make, if you're into this sort of thing and a bit of a law geek like I am, it does make interesting reading. But if any of you are suffering from insomnia, then I would suggest that you do read the Court of Appeal judgment. So I think just trying to break it down a little bit and make it a little bit more simple, just to see what the basic arguments were, and because some of the arguments were very specific to the actual circumstances of the case, which probably won't have much relevance going forward for other cases. But the 2 arguments for the Court of Appeal and the ones that they had to consider were effectively twofold. The first one was that the path, the claimant argued, was highway constructed by a highway authority within the meaning of section 36(2)A of the 1980 Act, or that the path was one of those highways which immediately before the commencement of the Act were highways maintainable at public expense within the meaning of section 36(1) of the 1980 Act. So the council denied liability on the basis that the path was a public right-of-way, but not highway maintainable at public expense, and therefore the Act didn't apply. So looking at option 1, which was the first issue that the Court of Appeal had to consider, the claimant argued for a very literal interpretation of this section. First of all, that the path was constructed by the council's predecessor, which was accepted, that the council's predecessor was a highway authority, and that therefore the path was a highway constructed by a highway authority, and that such highways are therefore maintainable at public expense by virtue of section 36. A finding on this basis would have had huge implications for local authorities in England and Wales, a massive issue, because that would mean that instead of having the 2 hats where a local authority who was a highway authority but also constructed other paths and roads in other departments such as housing or in their local amenities department or their parks, that because they were a highway authority, therefore all paths built by that local authority would become highway maintainable at public expense, and that could potentially mean that there would be paths constructed within the authority that the highway department had absolutely no idea that they were responsible for. So that would have had a huge impact across the country. Fortunately for everybody, that the council's interpretation of the Act was preferred. So the council contended that Section 36(2)A only applied where the highway authority was constructing a highway whilst acting in its capacity as a highway authority. Local authorities, of course, have many functions, and although they are one corporate body, it's they do have different functions across the whole piece. And it was likely in this case that the council's predecessor had laid the park out exercising its public amenity functions under the Public Health Act of 1875, rather than as a highway authority exercising its powers to build new highways. And the Court of Appeal preferred this interpretation and also concluded that the obiter comments in Gulliksen that it wasn't necessary for the council to have been acting as a highway authority for the highway to be accepted as a highway maintainable public expense was wrong, which is really good news as far as anybody arguing Gulliksen cases is concerned. And it was held that the early decision in that case of Neuberger was correct, and for Section 36(2)A to apply, it wasn't enough for the council to simply have been the highway authority. They must have actually been acting as the highway authority and exercising those powers when the path was constructed. So huge sigh of relief all round in relation to that option. Section 2, and the option 2, was under Section 36(1) of the Highways Act 1980, that whether the footpath was maintainable under Section 36, that it was because it was already maintainable at public expense under the previous Highway Act in 1959. And in relation to that, the claimant argued that the path she tripped on was a public path within the meaning of the terms in the National Parks and Access to Countrysides Act 1949. Under that Act, all public paths in existence when it came into force were repairable by the inhabitants at large, and by Section 38 of the Highways Act 1959, highways which were previously maintainable by the inhabitants of large became highway maintainable at public expense. The crucial question was the path a highway on the 16th of December 1949 when the National Parks and Access to Countryside Act came into force? The council argued that it wasn't, because nobody knew precisely when this path had come into existence. And just to recap, a highway can be created by express dedication by the landowner, deemed dedication under Section 31 of the 1980 Act, or dedication inferred at common law. And that would and did cause big problems for the claimant, as whilst she could demonstrate recent continued use, she couldn't prove when the path was put in between 1930 and 1949. So she couldn't succeed on A or B. So the question that the court focused on was whether or not she could infer at common law that there had been dedication of this particular footpath. The burden of the proof rests very much with the claimant to evidence continuous and unobstructed use over a long period. And as I said, the council argued that it wasn't clear when that path had been put in. So enter retrospective dedication. So the case going back again a long time to the case of Turner and Walsh in 1881. And the court in that case said, where a dedication is inferred from long and continuous period of use, the dedication is deemed to have occurred at the beginning of the period of use. So in this case, therefore, the dedication was deemed to have occurred when the park was laid out and started to be used probably in the 1930s. And that was obviously well before the coming into force of the 1949 Act. So it was not just from the 20 years prior to the issue arising, as it would be if you were looking at Section 31 of the Highways Act. The claimant therefore succeeded in establishing that the path was a highway maintainable at public expense by reason of Section 36(1) of the Highways Act, on the basis that it was deemed to have been a public right of way, as from the point it started to be used in the 1930s. It was a highway, therefore, on December 16th, 1949. In December 1949, it became a highway repairable by the inhabitants at large. And then it became a highway maintainable at public expense by reason of Section 38 of the 1959 Act, and remained so under the 1980 Act. And therefore, the highway was maintainable by the local authority under Section 41 of the 1980 Act. So just looking at that case and how potentially Barlow has impacted on Gulliksen and McGeown, I think in relation to all these cases, none of them have really established any new law. They've just really highlighted the law as it has always been. So I think as far as Gulliksen is concerned, then it's strengthened very much the two hats argument, that the local authority doesn't need to be there is a two hats argument that a local authority when constructing paths would normally have to be exercising a highway authority in order for that to be highway maintainable at public expense, unless of course that it had been constructed under Part 5 of the 1957 Act. There's now no question of pre-1959 highways being deemed as highway maintainable at public expense simply because it was constructed by a highway authority or its predecessor, which I think is good news. And also, if the council wasn't exercising a highway authority function, it's not going to be a highway maintainable at public expense without more evidence or an indication that that there's more history behind that. In relation to McGeown, the obiter comments made about McGeown could signal future difficulties in relying on the defence. His interpretation was that the rule applies where a person is only lawfully on the defendant's land because of the existence of the public right of way which he or she is using. So if you say we're going to a park and you were going to use the facilities and you weren't just using the highway as a cut through from one area to another, then it's likely that it would be very difficult for you to argue that the McGeown defence should apply. So again, it can be quite case specific. If the claimant says, well, I was walking through this area to get from A to B, then I think you're in a much stronger position to say that actually they were using it as a public right of way and not as a visitor using the park itself. But again, that isn't something that is new and was referred to as obiter within the McGeown judgment itself, right, back when that case was considered. So I think key points in conclusion, Gulliksen, if it's a highway and was built under the Housing Act powers, it's going to be highway maintainable at public expense. So don't admit that the Occupiers Liability Act 1957 applies in such cases, because it doesn't. Pre-1949 paths, if a path is a highway and was dedicated before December 1949, it's going to be highway maintainable at public expense. So do make sure that you are looking at the history of a particular path. It might be useful to revisit paths previously assumed to simply be rights of way and give consideration as to whether the path was constructed by a local authority exercising a highway in function, or whether the path had uninterrupted public use prior to the 16th of December 1949, and not just that it had 20 years user. I think it would be sensible to go back and have a look at that. So that is a whistle-stop tour through this area of law. I know that there's a lot to take in, and if anybody does have any questions, I will endeavour to answer some of those. But thank you very much for listening.